Sure. So when we created the title, we kept working with it, and so it got modified a little bit. But essentially, we're going to be taking just an entire defensive approach in protecting your case and protecting the testimony that comes out in your case. And that's going to include how you defend a depo, how you prep witnesses, how you prep your client most importantly, and how you prep your experts most importantly, and some of the legal pitfalls you can run into and how you dodge those along the way. So it should be, it's going to be interesting because it's not, it doesn't, we don't have, when we defend depots, we don't generally order the videos because we're not going to play the defense attorneys questioning our experts or our client at trial. So there's a couple that we actually did order to kind of show these points or that we had on hand. But otherwise, this is one of those ones where if people have questions, fire them off. Ideally, this turns into a discussion more than a lecture, and because there's just not a lot of video that you can really get from being defensive. There is some, but not a lot. So
it's your job to monitor the Q&A, answer the questions, typing when you can, but when there's good questions you think are generally applicable to everybody, make sure you pause, Khail, and ask them.
That's fine. Will do. All right, let's get rolling.
I just want everybody to know that if you missed yesterday's program, you missed Khail Parris and Alex Wheel, not Khail, but Khail's superseding beneficiary.
It happens every time.
No, I'm joking. Anyways, I'm going to send out the notes from that program. They're about 9 pages long, but it was a great program. I'm really, something the Parris firm has done better than any firm I've ever seen, which is getting juries to really place a value on the loss, on the invisible injuries of PTSD, chronic pain, and depression and anxiety. And we had Dr. Redding on yesterday, which is an expert psychiatrist that you guys have utilized.
Psychologist.
12 years in helping juries to understand. And we're going to do another program with Rex and Alex with the showing the actual testimony. Because it's one thing to have the evidence, but it's another thing how to present it most effectively with an expert. Getting them off the stand, having them draw, switching places with them, and asking the right follow-up questions. Rex Parris is par excellence. And that examination that we're going to show from the Lenning case, which, I think a lot of people know because we spent 12 programs doing it early on in the pandemic, but they got a monstrous verdict. They had a monstrous verdict on, some people call it a nuclear verdict, but that's what they do. Is it, if people really saw the value of all the extra pain people suffer and knew how to monetize it, would we all be doing a little bit better? I think so. But we're going to replay this program on October 27th. It's a Tuesday. So if you have the notes and you review the notes and you watch the program, your retention will go up at least 3-fold. That's what the neuroscience told us. All right. I just made that up, but at least twice.
It sounded persuasive.
You were confident, Dan. That's all that matters.
You know what? Great point. It's so much a trial.
All right. Let's get started.
Let's get rocking.
All right. So where we're going to start and why we want to start here is because we're going to start with how you defend a depo. And the reason we're starting with that is because how you defend a depo is going to dictate a lot of what your prep is. A lot of attorneys out there seem to think that when you go and defend a depo, you're just there to preserve objections as to form. And technically you are, but that's in our minds, that's the least of your worries. That's the bottom of the priorities when we go in and we're trying to essentially prevent bad testimony from coming out and make certain that good testimony does come out. So kind of for this, what we're going to use is we're going to use a case that we've talked about on here. Some of you may have seen it, but if you haven't, you can get, Trial Lawyers University, Dan?
Correct.
And you can go back and watch it. But it was a Tapia case. We did the case against Tesla, and it was a Cripps case where our biggest concern was the fact that she had a prior Cripps injury in her wrist in 2005 or thereabouts, and she had a work comp case for it. And once the work comp case settled, the Cripps went away. And just thinking about it, you can kind of see why that's a problem. We did a bunch of focus groups on it. And when that came in, our verdict fell by like, I think it was like 70% or something like that. And so the big fight that we had was we had to make certain that it stayed out as much as possible. And if it was going to come in, we had to make certain that they didn't get a whole lot about it. And so in doing that, we knew from the outset that's where we were going. And the two people most responsible for that are always going to be, in a CRIPS case, it's going to be your client and it's going to be the pain management specialist. And so this was the interference that we ran with the client, or the defense we played.
Okay, so if a question it requires you to guess, you should tell me, I don't know.
Entonces, si una respuesta requiere que usted adivine, debería decirme, no lo sé. Okay.
That would be incorrect. If it requires a guess, she should not say, I don't know. She should say that I can only guess.
So,
Well, I think she should say, I don't know the answer to the question.
I do not appreciate that you suggest to my client how they should testify based on your question, which is unacceptable to me. So if she says she would have to guess, you can then choose to do what you want. But telling her how to answer counsel is not right or fair.
So the bottom line, Ms. Tapia, is that if you don't know the answer to a question, rather than guessing, you can tell me you don't know. This deposition may.
So that's the admonition. I mean, this kind of shows how quick you need to get in there, and you need to essentially occupy the defense attorney's mind. One of the biggest things that we've kind of begun to learn over the years is that since the attorney at a deposition is almost never going to be showed to the jury, you can say whatever you want so long as you're being respectful, and the judge isn't going to get upset at you. And so what we try to do is we try to have the opposing attorney focus as much on us as possible, and it happens right at the beginning. Because I also think that at the beginning of the deposition, even if you've done 1,000 depositions, there's always a little bit of nerves that are still flying. And so if you jump in the defense attorney's space right at that moment, the nerves shoot up tenfold, and they're already nervous and they're already thinking about you.
It's also, I think, important to note the kind of objections you're making. So Bruce, Khail, me, we'll make longer objections and force a meet and confer. So over and over again, you'll hear Bruce, I think in this clip, say, I'm not just talking to talk. Please engage with me. Please meet and confer on my objections. That focuses more time and more energy because now he's trying to be clever speaking to you rather than being clever with his questions with your client.
And that there's a good exchange here, because a lot of people are probably wondering, well, what about speaking objections? See how it plays out.
A few hours, but at any time, except for when a question is being asked and you haven't responded yet, you may take a break to talk to your counsel, to get up and stretch and walk, or do whatever you need to do. All right? And
esta declaración jurada puede tardar
for the record, so there's no confusion, my client will not be walking during, before, or after the deposition, as counsel knows. She's unable to walk. So to suggest that is, I know, inadvertence on your part rather than deliberate.
She can walk. She has crutches. So she actually can get up out of that wheelchair. And I think she brought her crutches, but she left them in the car at our direction. It's just occupying a space. That's all that's going on.
Have you ever heard the term complex regional pain syndrome?
¿Alguna vez ha oído el término síndrome del dolor regional complejo?
I'll instruct her not to answer that question as phrased.
Have you ever heard the term complex regional pain syndrome?
¿Alguna vez ha oído el término complex regional pain syndrome, o sea, síndrome o trastorno de dolor regional complejo?
Identical question. I'll instruct her not to answer that question as phrased.
Can you mark that, please? Thank you.
Notice Bruce's hand too. I think for the plaintiff depo, for anybody, you'll see that, it's not enough just to get her to not talk for a second. Bruce's hand will be on her shoulder halfway through the question so that he gives himself time and space to make whatever objection he wants. He's telling her, it's not your turn to speak yet.
Yeah, and the one thing I wanted to note on top of that is we're only 40 minutes into the depo, and there's already instructions on what is the pivotal issue of the entire case. And it looks improper, but just wait. And there's a good explanation as to why you can get away with these kinds of things and why you should do it.
You can mark all you want, but you are now invading the attorney-client privilege, counsel. If it comes from, let me finish.
I know.
Let me finish, please. If it comes from anything I say, and you are now asking her, that is called attorney-client privilege. It is one of the very sacred areas I can instruct her not to answer. If you want to clean up the question and simply say, other than from your attorney, you have all the right to do so. You can note it all you want, and if you want, you can call the court today probably and get a ruling on that.
And you can, the speaking objections would be appreciated. Non-speaking objections would be appreciated.
I'm going to do whatever I have to do to protect my client. Well, if you find that offensive, I apologize. But if you don't want to meet and confer on easy ways to clean up a question that may invade and will invade the attorney-client privilege, I will do what I have to do to protect my client's rights.
All right. Did you ever miss?
And so that's how you get away with speaking objections. Is it's not a speaking objection, it's a meet and confer. Especially well on instructions, because usually they're going to claim they're going to file a motion to compel on the instructions not to answer. They're probably going to get the answer anyways, but what you're trying to do is you're trying to occupy so much of their mental endurance that they just slowly wear down, their mental bandwidth, like we've talked about, that they slowly wear down, and it's just exhausting for them to even be there. You're also giving your client a nice little breather, and they get to actually think and kind of just relax a little bit during what is normally a tense situation for them.
So let me ask you, in the preparation stages, does the client know that when you put their hand on the shoulder, that means pause, I'm about to say something before you answer, so just don't start talking, I will preface something? Is that part of the preparation process?
Yeah, I mean, usually I'll tell people that, but I've had times where I don't tell people that, and generally
they get it.
Hands waving in your face, you're not gonna jump to start talking.
Right.
Or if a hand's on your shoulder, you look, and then I'll usually just say, hold on.
Yeah. Okay.
From work at Mi Pueblo due to your right hand and wrist injury.
Assumes facts, not in evidence, that there was both a right hand and wrist injury. She definitively stated it was the right wrist that may have had pain going into the fingers.
Okay. Can we agree that your fingers are part of your hand?
That was a mistake on the defense attorney's part, and that's exactly what Bruce wanted. The defense attorney is now engaging Bruce and not asking what is the most important issue in the case. And that's what you want to do when you're defending a depo, where you're trying to essentially prevent them from getting bad testimony for your case.
It's also, so I think when we're prepping our depos and doing everything, we're looking for great clips that we can show the jury. So even if they're getting some good testimony, if Bruce's voice is spattered throughout it, you're ruining these clips, the impeachment value of those tests, of those quotes when they come out at trial.
Exactly. And if you've ever done deposition clipping before, you know how frustrating that is. I mean, it's just irritating beyond belief.
There was no injury to the finger console, and if you want to go anatomically with me, we can do so, but I don't think you're going to be able to. So if you want to play that game with me on the record, I am more than welcome to do that.
Hey, counsel, just for the record, and you can have a unexpressed thought during the deposition. You answer my question.
¿Puede contestar mi pregunta?
Do you remember the question?
¿Recuerda la pregunta? No.
Okay, let me try it again. The injury that you sustained in 2007 to your wrist, correct? You remember that? We talked about it?
She did not sustain an injury to her wrist in 2007. That mischaracterizes the testimony. It's vague, ambiguous, unintelligible. she had symptoms going through 2007.
The speaking objections are, just make your objection when you move on.
We cannot speak at the same time.
Right.
So you're going to need to let me finish. I do not interrupt you. I will expect the same courtesy. If you don't like what I'm doing, feel free to suspend the deposition. Feel free to get a referee. But I have told you multiple times now, I'm going to do what I need to do to protect my client's interests.
Counsel, just keep it to non-speaking objections. I think that's the rule. So, and you know that's the rule.
What rule is that?
The local rule. And
please share with me the local rule. Please share with me the local rule. I don't know.
I'm not here to argue with you, all right? I'm here to ask your client questions, all right? If you want me to suspend the deposition, I'll do it. Is that your desire?
If you want to do it.
You want me to?
If you want to do it at your own risk. If you want to do it, do not think you will intimidate or threaten me. That will not work. You should know that by now. If you want to suspend it, please do so. Get a court order if you think I'm doing something wrong, but I'm going to make my objections. If you don't like that, it is unfortunate, but I am not going to change my style for you or anybody else.
That's great. All right. So, back to the deposition. Ma'am, we talked about the injury that you had to your right upper extremity in 2005. Do you recall that?
So you can already see he's getting frustrated, and his questions are going all over the place, and they're starting to move around. And that there's nothing that he can do to stop that from a physiological perspective. As soon as his heart rate starts to rise, as soon as he starts to engage in that argument, his mental capacity is going down. And it shows. I mean, you can see he's getting frustrated, and he's not asking questions that make sense. He changed from 2005 to 2007, and it keeps going. So that's the reason why we're doing it, just so everybody understands that.
Señora, hemos hablado de la lesión que sostuvo en la extremidad derecha superior en el 2005, ¿lo recuerda?
Mischaracterized his testimony, assuming facts not in evidence that it is now gone up to the right extremity.
Well, that's what it's referred to in all the medical records that you've seen and I've seen relative to that injury.
So now you don't like the objection I'm making when I don't make a speaking objection.
It was a speaking objection.
So you now comment on it, so now you're inviting a response.
Counsel, do you want me to be able to take your client's deposition, or you just want to be a grandstand for your folks?
Now you're suggesting I'm grandstanding. Counsel, you're pushing it. You know what? Keep doing it, and I'm going to keep doing it, and we'll see how clear this transcript gets for you.
And that's very unprofessional, and it's surprising that you would say something like that.
Well, you know what? But if you suggest that I grandstand, I'm going to treat you with kind, counsel. You want to pull back and go like that? I'm all for it.
I think this videotape and the transcript will speak for itself as far as grandstanding. So
right,
I'll withdraw my comment. Let it speak for itself.
Okay. You don't get to withdraw comments.
Let me know when you're done. Do you want to take a break so you can go out and get yourself under control?
Get myself under control.
Seriously.
All right.
I'm trying to conduct a deposition here.
Let's keep going.
Okay. So that means that I get to ask a question, right?
If it's an intelligent question, you can ask all the questions you want.
And you're the guidepost for what's intelligent and what's not, right?
For this deposition as to my client, I am the only guidepost.
Okay, well, let me do my best, all right?
You'll do your best.
All right.
I mean, it's a fire. You just need to keep feeding it because he's wasting time. He's not even getting testimony out of our client. And what's the whole point of it? I mean, what's the benefit to the defense attorney in fighting with Bruce? He's never going to prove Bruce wrong. I mean, you want to occupy as much of their head and you want to occupy as much as the deposition as possible.
Yeah, I mean, so I would also say, usually I'm a little less than what you're saying from Bruce, but I will play a game, every 4 questions, every 3 questions, you want to have yourself either objecting, asking them to rephrase, asking for a readback, asking your client if they understood the question. There are so many ways to interject yourself onto the record in ways that, you don't have to be fully confrontational or combative to make sure that they're thinking about you as much as they're thinking about your client.
Yeah. You have to, and this is where I think on prior ones that we've done, I've said that the most valuable thing that I've ever learned is the idea of mental bandwidth, because there's so many applications, and this is a prime example of when you can exhaust somebody's mental bandwidth for the benefit of you and your case.
Que puedo, sí. Bien.
You remember when we talked about your injury to your right upper extremity in 2005?
¿Recuerda cuando hablamos de la lesión en la extremidad derecha superior?
Vague and ambiguous as phrases says, do you remember when we talked about your injury in 2005? At best, you would be talking about an injury that occurred in 2005. Therefore, it's unintelligible as phrases.
In your mind, what is preventing your right leg from bending at the knee? If you know.
En su mente, ¿qué es lo que le impide a la pierna derecha doblarse a la rodilla, a nivel de la rodilla, si es que lo sabe?
That is, I'm not going to take my client's second deposition and have her try to formulate a medical diagnosis for you if that's what you're doing.
That's not what I'm
Your
doing.
question was, in your mind, why do you think your right leg can't bend? That is a medical diagnosis concept.
No, it's not.
What is it?
It's her perception of a body part and why she's unable to bend her leg. And
That is a medical diagnosis.
No, it
I'm
isn't.
instructing you to answer, go to court on it.
Okay.
Lay the foundation if you want to get there, but I'm not going to have her play doctor with you.
Not ask her to play doctor.
You are asking, in her mind, why does she think her leg can't bend? That is as clear a question of a medical doctor as there are.
This is a common trick that defense attorneys try to pull. And really, there's no rule that allows you to instruct them not to answer when it calls for an expert opinion. But the way that you can get away with it is if you heard Bruce in that he said, lay the correct foundation first, and then you can get an answer to what you're looking for. And that's whenever you instruct somebody not to answer that's beyond like privilege and things like that, the backup that you want to have is that you can go in if they actually do file the motion. And in my experience, most of the time they don't. But if they actually do file the motion, you can come in and say, Judge, there was an easy way to get around it. They just didn't want to do it for whatever reason. And then you're less likely to get sanctioned. You're less likely to get in trouble. Now, a lot of people are probably thinking that Bruce is being an asshole. And to some extent, that is true. It is true, but there's a difference here. We're here to try to protect our case as much as possible. And if it means at times that you have to act like an asshole, that's something that it's just part of our job. And that's totally fine. And I think where it gets distinguished on being an asshole and also being civil at the same time is throughout the entire time, he's not telling him to shut up. He's not calling him an idiot. He's not swearing at him. And at the end of this depo, there is always, always, always an effort to shake hands, wipe the dust off, and we're friends again.
And I think that takes a lot of the temperature out of the room. After each break, Bruce will lean back and smile at opposing counsel. He'll ask him, how his baseball team did that day, what he's doing with his wife this weekend. Bruce maintains, a very good relationship with opposing counsel so that they understand, once we get back in there, I think there's a little bit more latitude than you get if you get off the record and you smile, deviously at them and laugh about how you're winning. If they understand you're just there to do your job and to push forward and do the best you can, I think they give you more slack and more credibility, inside the depot.
There's a quick from on the chat. So Jeffrey, if you put your questions in the Q&A, we'd prefer that for everybody. Sarah too. He says, sounds like you're needlessly obstructing. What would you say to that? That Bruce is needlessly obstructing this deposition?
I would say we're definitely obstructing, but it's not needlessly.
Right.
We're doing it intentionally.
Yeah.
I mean, I hope this doesn't get out to a defense attorney because it'll be attached to every motion if it gets filed. But yes. I mean, let's not play games about this. Yes, we are obstructing, and we're obstructing with the intent of protecting our case and protecting our client.
Right.
I mean, I understand people are saying, well, it seems like it's not against or it's against the rules. You shouldn't do that. I mean, if you're going to play like that, you're going to get sand in your face every single time, and you're going to be fighting on a different battlefield than everybody else is. Yeah. Push the envelope. I really think everybody should push the envelope. And at the end of the day, let's say you do get sanctioned. You do have to have an awareness of what type of case you're litigating. If you have a soft tissue case and you're going to get sanctioned, you shouldn't risk getting sanctioned for $4,000 or $5,000. But if you have a case that's a catastrophic injury like we had here, where it's a Crips and she's in a wheelchair, if I get sanctioned $4,000 or $5,000, but they don't get any good testimony, I would have paid that at the outset. Let's skip the depo. I'll just give them the $4,000.
Yeah. Well, and then also breaking it up is still to your advantage. So say, you know, they get through a third, 40% of his depo, he throws up his hands and he says, Bruce, I'm going to take you to court on this. They suspend the depo, they file the motion, it's another 60 days, they bring them back, you know, then we have a new grounds that I would talk about. I'd be like, you asked her about that in the first depo, counsel, we're not going backwards, we're going forward. And so you're still getting that choppiness that you want. You're still preventing those kind of clips from making its way cleanly in front of a jury regarding admissions that you feel were unfair to begin with.
Yeah, and anybody who's ever taken a choppy depo or a depo where you've had an obstructionist on the other side, you know how hard it is to keep everything straight in your mind and to have a cohesive depo. I get where people are coming from when they say that it seems like we're obstructing, and I agree with you. But that's the point. I mean, it's just the point. It's part of our job.
The art too is to know where the line is. So there's protecting your client in a way that you preserve, you know, basically if your goal is to obstruct as much as possible, but stay out of court, there's a lot of tactics that I think this presentation would focus on how to do that in a way where you're getting the most bang for your buck without, you know, throwing out profanities or doing something completely improper that's going to get you sanctioned or get you in a lot of trouble.
Yeah. And the other thing I want to point out is that sometimes it makes sense to foul. Sometimes. And I think that litigation is no different. I think that sometimes you gotta commit a foul. Because I mean, it's just going to increase your likelihood of winning. And it's not so much that, a foul is always against the rules, but it's not so much like you're automatically tossed out of the game. It's not an ethical violation if you commit a foul.
It's more like the last 2 minutes of a basketball game.
Exactly. Exactly.
So, all right.
That goes on for a little bit longer. I don't want to waste too much time on that, but you get the idea. That also works for experts. And those experts are the ones that need your help the most, despite what most people think. I think generally people think that, oh, they're an expert, they're a pros pro. They're a pros pro at testifying, yes, but when you have a case, they're focusing on testifying, and it's very hard for an individual, it doesn't matter how smart you are, to focus on testifying and make certain that you have all of your facts in order. And that's why you need to be there to not only mess up the defense attorney's flow, but also feed information when it's necessary. So in this case, we had Dr. Feinberg. I cannot sing his praises enough. He was our pain management doctor. He's a fantastic doctor. And he's just overall a great guy. But I was sent up to defend his depo, and we had literally talked about it. And we had told Dr. Feinberg, be ready that I'm going to be in the defense attorney's face and I'm going to be going after him. And I thought the depo was going to be much longer than it was. I think it wound up being like an hour and a half total. And he was the guy, and he wound up carrying the day because they didn't get enough testimony from him.
What psychiatric condition did you refer to in your prior response?
Prior what?
Prior response.
Like to the last question?
There's 2 questions ago.
Can I get a read back 2 questions ago as answered?
This is a trick that you can use, by the way, that really throws off the flow. Because what happens is you have a flow going of question, question, question. And then when you have to pause it and the court reporter goes back 3-4 questions, everybody gets confused. And so you can create chaos before the good flow even starts and the good testimony starts to come out.
We talked about psychological condition, psychiatric condition.
Are those patients involved in litigation, or are they just people that come to you absent litigation?
One before that.
One before that. Do you have other patients like that where nothing seems to work?
Before that, you remember, but we'll play the game.
I want to remember. It's
Okay.
not a game.
Educating her and trying to pull her along in that direction.
Thank you.
Dan, I don't appreciate you calling this a game. I don't think it's funny. I don't think it's fun, and I don't think it's entertaining.
Okay, that's fine.
You keep those comments up, and I swear to you, this is going to become a very hostile deposition.
Okay.
You try to do it with Bruce. You're not going to try it with me.
Well,
okay?
first of all, anyway, all right, fine. I haven't tried anything with Bruce. I don't know what
Really?
you're talking about. Yeah.
Really? Do I need to go through the second?
Oh, whoops.